I want to thank all the senators on the Democratic side here that have spoken up over the course of this 30 hours. We're trying to address this issue, a very, very important issue of whether Senator Jeff Sessions should be Attorney General of the United States. And I have formal remarks here that I'd ask consent to put those formal remarks in the record.
Is there objection? Without objection.
And in the remarks that I'm going to give now, I may draw some of them from the formal remarks I have. I just want to say, I come from my home state, New Mexico, majority-minority state. We have, these are the rough numbers, but about 47% Hispanic, 10% Native American. Those are our large minority populations, majority-minority state. And I can tell you since this administration has come in, people are very worried about their voting rights. They're worried about their democracy. I've been home to New Mexico and heard the exchanges. I've heard the various emails. People are concerned about the issue that goes to the heart of this nomination, which is the voting, how Senator Sessions would behave as Attorney General on the issue of voting rights. And so I fully understand the importance of Rule 19 and civility. I try in my activity here on the Senate floor to be as civil as possible, but I think there's a bigger issue here. So I fully understand the importance of Rule 19. God knows we need to maintain civility in this esteemed body. But when a member of this body has chosen to be considered for an office outside this body, and in the case of Senator Sessions, for an office in a department in which he has previously served, then his record in that office, for better or worse, is critical to our consideration. When Mr. Sessions exercised his duties as United States Attorney in Alabama under the supervision of the United States Attorney General, the office he now seeks, his record on voting rights, the backbone of our democracy, was subject to serious question. In the context of this confirmation hearing, that record must be included in the context of this confirmation hearing. So here we are on the floor, we've debated. That record must be included in the debate on the floor. As Senator Warren has brought to our attention, it was the judgment of Coretta Scott King, widow of slain civil rights leader Martin Luther King, that he used the office of the United States Attorney for Alabama to quote, these are Coretta Scott King's words, to chill the free exercise of the vote by the black citizens. To chill the free exercise of the vote by black citizens, end quote. Start into the quote there. That was her opinion at the time. Similarly, in words of our former colleague, Senator Ted Kennedy, he was a disgrace to the Justice Department, the department for which Mr. Sessions will lead if he is confirmed. And I would like to read into the record today the letter from Mrs. King, which supports her opinion of Mr. Sessions' lack of commitment to justice for all, and leave it to my colleagues here today to assess in considering his nomination. And so, to me, that letter that she wrote back in March 19th, 1986, goes right to the heart of what we are debating here on the Senate floor. That what we are debating is our voting rights and whether we will have for the next 4 years or 8 years an Attorney General who's going to enforce the laws, particularly with regard to voting rights. And so here's her, and I'd first ask consent to put the letter in the record.
Is there objection? Without objection.
This letter starts on March the 19th, 1986. It's a letter from Coretta Scott King, Martin Luther King Jr. Center is at the top of the letterhead here for nonviolent social change. And she's writing a letter to Strom Thurmond. And she says, I write to express my sincere opposition to the confirmation of Jefferson B. Sessions as a federal district court judge for the Southern District of Alabama. My professional and personal roots in Alabama are deep and lasting. Anyone who has the power of his office as United States Attorney to intimidate and chill the free exercise of the ballot of the citizens should not be elevated to our courts. Mr. Sessions has used the awesome powers of his office in a shabby attempt to intimidate and frighten elderly black voters. For this reprehensible conduct, he should not be rewarded with a federal judgeship. I regret that a long-standing commitment prevents me from appearing in person to testify against this nominee. However, I have attached a copy of my statement opposing Mr. Sessions' confirmation, and I request that my statement as well as this letter be made a part of the hearing record. I do sincerely urge you to oppose the confirmation of Mr. Sessions. And there's a carbon copy of this to Senator Joe Biden. This happened in March of 1986, and Coretta Scott King is speaking out against Jeff Sessions, who was at the time the United States Attorney, and he was going to be promoted as a federal judge. We all know the history. He was not promoted as a federal judge. And here's her statement that she asked to be read at the Senate Judiciary Committee on Thursday, March the 13th, 1986. Mr. Chairman and members of the committee, thank you for allowing me this opportunity to express my strong opposition to the nomination of Jefferson Sessions for a federal district judgeship for the Southern District of Alabama. My long-standing commitment, which I shared with my husband, Martin, to protect and enhance the rights of black Americans, rights which include equal justice to the democratic process, compels me to testify today. Civil rights leaders, including my husband and Albert Turner, have fought long and hard to achieve free and unfettered access to the ballot box. Mr. Sessions has used the awesome power of his office to chill the free exercise of the vote by black citizens in the district he now serves. He now seeks to serve as a federal judge. This simply cannot be allowed to happen. Mr. Sessions' conduct as U.S. Attorney, from his politically motivated voting fraud prosecutions to his indifference towards criminal violations of civil rights laws, indicates that he lacks the temperament, fairness, and judgment to be a federal judge. The Voting Rights Act was and still is vitally important to the future of democracy in the United States. I was privileged to join Martin and many others during the Selma to Montgomery March for voting rights in 1965. Martin was particularly impressed by the determination to get the franchise of blacks in Selma and neighboring Perry County. As he wrote, certainly no community in the history of the Negro struggle has responded with the enthusiasm of Selma and her neighboring town of Marion, where Birmingham depended largely upon students and unemployed adults to participate in nonviolent protest of the denial of the franchise. Selma was involved fully 10% of the Negro population in active demonstrations, and at least half the Negro population in Marion was arrested on one day. Martin was referring, of course, to a group that included the defendants recently prosecuted for assisting elderly and illiterate blacks to exercise that franchise. In fact, Martin anticipated from the depth of their commitment 20 years ago that a united political organization would remain in Perry County long after other marches had left. This organization, the Perry County Civil League, started by Mr. Turner, Mr. Hogue, and others, as Martin predicted, continued to direct the drive for votes and other rights. In the years since the Voting Rights Act was passed, black Americans in Marion, Selma, and elsewhere have made important strides in their struggle to participate actively in the electoral process. The number of blacks registered to vote in key southern states has doubled since 1965. This would not have been possible without the Voting Rights Act. However, blacks still fall short of having equal participation in the electoral process, particularly in the South. Efforts continue to be made to deny blacks access to the polls, even where blacks constitute the majority of the voters. It has been a long uphill struggle to keep alive the vital legislation that protects the most fundamental right to vote. A person who has exhibited so much hostility, here she's talking about Jeff Sessions, a person who has exhibited so much hostility to the enforcement of those laws and thus to the exercise of those rights by black people should not be elevated to the federal bench. The irony of Mr. Sessions' nomination is that, if confirmed, he will be given life tenure for doing with a federal prosecution what the local sheriffs accomplished 20 years ago with clubs and cattle prods. 20 years ago, when we marched from Selma to Montgomery, the fear of voting was real, as the broken bones and bloody heads in Selma and Marion bore witness. As my husband wrote at the time, and I quote, "It was not just a sick imagination that conjured up the vision of a public official sworn to uphold the law, who enforced the inhumane march upon hundreds of Negro children, who ordered the Reverend James Bevel to be chained to his sickbed, who clubbed a Negro woman registrant, and who callously inflicted repeated brutalities and indignities upon nonviolent Negroes peacefully petitioning for their constitutional right to vote. Free exercise of voting rights is so fundamental to American democracy that we cannot tolerate any form of infringement of those rights. Of all the groups who have been disenfranchised in our nation's history, none has struggled longer or suffered more in the attempt to win the vote than black citizens. No group has had access to the ballot box denied so persistently and intently. Over the past century, a broad array of schemes have been used in attempts to block the black vote. The range of techniques developed with the purpose of representing black voting rights run the gamut, from straightforward application of brutality against black citizens who tried to vote to such legalized frauds as the grandfather clause exclusions and rigged literacy tests. The actions taken by Mr. Sessions in regard to the 1984 voting fraud prosecutions represent just one more technique used to intimidate black voters and thus deny them this precious franchise. The investigation into the absentee voting process were conducted only in the black belt counties where blacks had finally achieved political power in local government. Whites had been using the absentee process to their advantage for years without incident, and then when blacks, realizing its strength, began to use it with success, criminal investigations were begun. In these investigations, Mr. Sessions, as U.S. Attorney, exhibited an eagerness to bring to trial and convict 3 leaders of the Perry County Civil League, including Albert Turner, despite evidence clearly demonstrating their innocence of any wrongdoing. Furthermore, in initiating the case, Mr. Sessions ignored allegations of similar behavior by whites, choosing instead to chill the exercise of the franchise by blacks by his misguided investigation. In fact, Mr. Sessions sought to punish older black civil rights activists, advisors, and colleagues of my husband who had been key figures in the civil rights movement in the 1960s. These were persons who, realizing the potential of the absentee vote among blacks, had learned to use the process within the bounds of the legality and taught others to do the same. And the only sin they committed was being too successful in gaining votes. The scope and character of the investigations conducted by Mr. Sessions also warrant grave concern. Witnesses were selectively chosen in accordance with the favorability of their testimony in the government's case. Also, the prosecution illegally withheld from the defense critical statements made by witnesses. Witnesses who did not testify were pressured and intimidated into submitting the, quote, correct testimony. Many elderly blacks were visited multiple times by the FBI, who then hauled them over 180 miles by bus to a grand jury in Mobile when they could more easily have testified at a grand jury 20 miles away in Selma. These voters and others have announced they are now never going to vote again. I urge you to consider carefully Mr. Sessions' conduct in these matters. Such a review, I believe, raises serious questions about his commitment to the protection of the voting rights of all American citizens, and consequently, his fair and unbiased judgment regarding this fundamental right. When the circumstances and facts surrounding the indictments of Al Turner, his wife, Evelyn, and Spencer Hogue are analyzed, it becomes clear that the motivation was political and the result frightening. The wide-scale chill of the exercise of the ballot for blacks who suffered so much to receive the right in the first place. Therefore, it is my strongly held view that the appointment of Jefferson Sessions to the federal bench would irreparably damage the work of my husband, Al Turner, and countless others who risked their lives and freedom over the past 20 years to ensure equal participation in our democratic system. The exercise of the franchise is an essential means by which our citizens ensure that those who are governing will be responsible. My husband called it the #1 civil right. The denial of access to the ballot box ultimately results in the denial of other fundamental rights. For it is only when the poor and disadvantaged are empowered that they are able to participate actively in the solutions to their own problems. We still have a long way to go before we can say what minorities no longer need to be concerned about discrimination at the polls. Blacks, Hispanics, Native American, and Asian Americans are grossly underrepresented at every level of government in America. If we are going to make our timeless dream of justice through democracy a reality, we will take every possible step to ensure that the spirit and intent of the Voting Rights Act of 1965 and the 15th Amendment of the Constitution is honored. The federal courts hold a unique position in our constitutional system, ensuring that minorities and other citizens without political power have a forum in which to vindicate their rights. Because of this unique role, it is essential that the people selected to be federal judges respect the basic tenets of our legal system, respect for individual rights, and a commitment to equal justice for all. The integrity of the courts, and thus the rights they protect, can only be maintained if citizens feel confident that those selected as federal judges will be able to judge with fairness others holding differing visions. I do not believe Jefferson Sessions possesses the requisite judgment, competence, and sensitivity to the rights guaranteed by the federal civil rights laws to qualify for appointment to the federal district court. Based on his record, I believe his confirmation would have a devastating effect on not only the judicial system in Alabama, but also on the progress we have made everywhere toward fulfilling my husband's dream he envisioned over 20 years ago. I therefore urge the Senate Judiciary Committee to deny his confirmation, and I thank you for allowing me to share those views. Now, this was a letter that Coretta Scott King, I just finished reading there, in March 19th, 1986. We know the result of that. After the testimony was taken, Jeff Sessions, because of his record at the time, was not allowed to become a federal judge. And today, the issue that we have before us, is he fit to be our Attorney General of the United States based on his overall record? And this is part of the record. And so when the majority leader comes to the floor and strikes the words of Elizabeth Warren, just reading parts of this letter, he's not allowing the full record to be before the American people, and he's not allowing a full debate to occur here in this chamber. And that's really what this is about today. Are we going to, as a Senate, where we have debate, we have open debate, and we're able to say things about one another? And especially in this case, this just isn't a debate from one senator to the another. And as the Senator Warren, it was said that she impugned the integrity of Senator Sessions. Senator Sessions is in a different category here today. Senator Sessions is seeking the office of U.S. Attorney General. It's the most important law office in the land, most important law enforcement office. This is an office where you can be active and go out and file civil rights cases. You can protect voting rights. You can do numerous things. And so this is an awesome responsibility. And so this should be part of the record. And I believe it's very, very important that we put it in the record, that we talk about it, and that we look in the whole picture. And as I've said earlier, I rise in opposition to the confirmation of Senator Sessions to be Attorney General. It's never easy to oppose a president's cabinet nominee, especially when one is your Senate colleague. And I generally think the president should be able to assemble his team. But with this president, we're in uncharted territory. President Trump doesn't want to hire a team that will represent the American people. Many of the nominees are billionaires who are out of touch with the struggles of average Americans. And many of them have shown great disdain for the very agencies they will lead. People like Betsy DeVos, a billionaire with zero experience in public schools, selected to run the education department. As we all know, yesterday we saw what happened. Two courageous Republicans, Lisa Murkowski and Susan Collins, voted against Betsy DeVos, and in an unprecedented move, the President of the United States had to come here and sit where the President of the Senate is and break the tie-breaking vote in order to get her through. And I think we're going to look back on that as a sad day for public education, because she sure doesn't stand up for public education. People like Scott Pruitt to be head of the Environmental Protection Agency, which he sued many times. When the people nominated to the president's cabinet are intent on dismantling the very agency they are nominated to run, our constitutional role of advice and consent takes on a new importance. But the position of Attorney General is unique. The nominee requires even more scrutiny. The Attorney General is our nation's chief law enforcement officer, with enormous power to either advance or roll back our constitutional protections. It resides in that one person. And the other important role of the Attorney General is to make sure that the president's obeying the law. And in this case, we got a real problem here. Within the first couple of weeks, the courts are calling the president in and telling him that he's issuing Muslim bans and other orders, and that he's violating the law. So we need an Attorney General who's going to stand up for what the law is, not be political and not be ideological. And that's why I think this position of the Attorney General is unique. The nominee requires even more scrutiny. The Attorney General is our nation's chief law enforcement officer with enormous power to either advance or roll back our constitutional protections. Perhaps Senator Sessions said it best during the confirmation hearing for Sally Yates to be Deputy Attorney General. In that hearing, Senator Sessions said, and I quote, "You have to watch out because people will be asking you to do things you just need to say no about." That's his full quote there, Senator Sessions. You have to watch out because people will be asking you to do things you just need to say no about, end quote. When he asked Ms. Yates, do you think the Attorney General has the responsibility to say no to the president if he asks for something that's improper? That's the standard we're looking at. Pretty tough standard. You're speaking truth to power, Attorney General to the President of the United States. I completely agree with Senator Sessions. The Attorney General has the responsibility, the duty to tell the President no when he is wrong. And that is why I cannot vote to confirm Senator Sessions. I don't have the faith that he will tell President Trump no when the situation requires it. But I have less faith that the president will listen. Sally Yates told him no. She refused to let the Justice Department defend the president's misguided travel ban. She was fired for doing exactly what the position of Attorney General requires. And when the acting AG Yates, said his travel ban was wrong, the president didn't simply relieve her of her position. Instead, he put out a press release attacking her personally. Sally Yates had served the country for almost 3 decades as a career prosecutor, Justice Department attorney. She deserved the president's respect, regardless of whether he agreed with her or not. Time and again, President Trump has shown that he will not tolerate dissent. You're either with him or in his mind, you're wrong, and you become the enemy. President Trump has put the bully back into the bully pulpit. He frequently and publicly lashes out against those who express different views. And more dangerously, he lashes out at the institutions that are the fabric of this democracy. This weekend, he attacked a federal judge who ruled against his travel ban, rather than respecting the rule of law and the co-equal judicial branch. He once again took to Twitter to personally denigrate the federal judge who dared rule against his policy, a federal judge who was appointed by George W. Bush. President Trump disparages the free press at every opportunity. Any article or story that is critical of his policies is now dubbed fake news. Members of the press are punished for coverage of the administration that he deems negative. He said he wants to weaken libel laws so it's easier for him to sue the press. President Trump will continue his assault on the First Amendment, defining the press that holds him accountable as the enemy, deriding and belittling those who speak out against him, attacking the free expression of religion, and targeting those who practice Islam. And when he takes these actions, it's up to the Attorney General of the United States to tell him he is wrong. That's where that awesome responsibility resides. It's up to the Attorney General to speak truth to power and to be ready to be fired for doing so. But it is far from clear that Senator Sessions will be that independent voice within the Department of Justice the American public needs. The Washington Post reports that Senator Sessions not only agreed with the president's flurry of extreme executive orders, but that he wanted the president to go further and faster. In an email to the Post, senior strategist Stephen Bannon said that throughout the campaign, Senator Sessions, and now I'm quoting from Stephen Bannon, Senator Sessions, quote, has been the fiercest, most dedicated, most loyal promoter in Congress of Trump's agenda, and has played a critical role as the clearinghouse for policy and philosophy to undergird the implementation of that agenda. What we are witnessing now is the birth of a new political order, end quote, Stephen Bannon. This is an amazing quote, contemporary quote from the president's top strategist. Everybody that's now talking in the press, and there are a lot of leaks out of this White House, says that many have called Stephen Bannon the puppeteer. He's the one telling Trump what to do, but it's absolutely clear of all the people in the White House, this is the guy that has the most clout. And it's a debate for all whether or not he is the puppeteer and telling the president what to do. But listen what he said again about Senator Sessions. Quote, has been the fiercest, most dedicated, and most loyal promoter in Congress of Trump's agenda, and has played a critical role as the clearinghouse for policy and philosophy to undergird the implementation of that agenda. What we are witnessing now is the birth of a new political order. I don't know what this new political order is. I mean, where you don't respect the rule of law and don't respect democracy. It's headed in the wrong direction, in my opinion. Mr. President, loyalty is a valued characteristic in politics, but the nation's chief law enforcement officer must be independent, first and foremost. I hearken back, Senator Sessions and I were both attorneys general back many years ago, and I remember doing that role at the state level. And it's an awesome role because almost early on in my administration, they brought me cases where Democrats who were in the state legislature were violating the law. And they said, you know, they're violating the law. You have to enforce the law. And I did, and we prosecuted people in my own party. We had many rulings that came in as Attorney General where people would say, interpret this law. And the law could be interpreted in a political way where you moved it towards your party, or the law could be interpreted the way it was written with fairness. And it ended up that we did everything we could to try to be fair and fair to the law and fair as it was written. And I don't think that Senator Sessions is able to do that, not only based on this history in Alabama as U.S. Attorney, but his entire career up to this date. Now, when we talk about loyalty being a valued characteristic in politics, the nation's chief law enforcement officer must be independent first and foremost. He or she must defend the Constitution and all Americans, not to be the president's architect of a new political order. That excludes many people. Mr. President, for these reasons, I must vote no on this nomination, and I request unanimous consent to place the Washington Post article I referred to in the record so that people can see that full article and be able to judge Steve Bannon's quote, who's the president's top strategist.
Without objection.
Thank you.